I never thought my forklift certification would become the center of a legal nightmare. But here I was, sitting in my living room in Henderson, Nevada, staring at an official HOA letter demanding I share my training materials with the entire neighborhood. My name is Peter Zander, and I had been living in the Sunset Ridge community for about 3 years. The place was nice enough, with well-maintained roads, a community pool, and strict landscaping rules that kept everything looking pristine. I worked as a warehouse operations manager for a large logistics company, and part of my job required me to be forklift certified. I had gone through extensive training, paid for by my employer, and maintained my certification with regular renewals and additional courses over the years. The trouble started on a Tuesday morning in March. I was loading some furniture into my truck, using the small forklift I kept in my garage for personal projects. I had bought it used a few years back, perfectly legal to own and operate on private property. My neighbor, Todd, had come over to ask if I could help him move some heavy equipment for his home renovation project. I agreed, and we spent about an hour carefully maneuvering pallets of tile and bags of concrete mix. Apparently, Karen Keller, the HOA president, had been watching from her window 3 houses down. By Thursday, I found the letter in my mailbox, typed on official HOA letterhead with that annoying serif font they always used. The letter stated that, as a certified forklift operator living within the community, I was required to provide free training sessions to any homeowner who requested them. Furthermore, I needed to submit all my training materials, certifications, and course documentation to the HOA office within 10 business days. The reasoning, according to Karen's eloquent prose, was that forklift operation constituted a specialized skill that could benefit the entire community, and therefore fell under the Community Improvement Clause in the HOA bylaws. I read it 3 times, each time growing more confused and irritated. The Community Improvement Clause was meant for things like neighborhood watch programs and volunteer landscaping days, not forcing residents to become unpaid instructors for their neighbors. I called my wife, Jennifer, who was at her office downtown. "Jen, you are not going to believe this." "What did the HOA do now?" she asked with a sigh. "We had dealt with them before over stupid things like the wrong shade of tan on our garage door and a mailbox that was apparently 2 inches too tall." I read her the letter verbatim. "That is insane," she said flatly. "They cannot force you to give up your work training materials. Those probably belong to your company anyway." Exactly what I was thinking. Plus, forklift certification is not something you just hand out. It requires actual training from certified instructors, written tests, practical examinations. I cannot just teach people in the street. Are you going to respond? I am going to ignore it and see what happens. That was my first mistake, not because ignoring it was wrong, but because I underestimated Karen Keller's determination to make my life difficult. 2 weeks later, I received a notice of violation. Failure to comply with HOA directive regarding community skills sharing program. Fine. $500, due immediately. Now I was angry. I drove straight to the HOA office, a small building near the community center. Karen was there, of course, sitting behind her desk like a judge on a throne. She was in her late 40s, with that particular haircut that seemed to be a requirement for neighborhood busybodies everywhere. Her blazer had shoulder pads that went out of style in the 90s, and her glasses hung on a chain around her neck. "Mr. Zander," she said coolly when I walked in, "I assume you are here about the fine." "You assume correctly. This is ridiculous, Karen. You cannot fine me for not teaching forklift classes. The bylaws clearly state that residents must contribute to community improvement initiatives when they possess specialized skills. That clause is about volunteering for neighborhood events, not about appropriating my professional certifications. The board has interpreted it more broadly. We have had several residents express interest in learning forklift operation for their personal projects. You have the skills and equipment. It only makes sense that you share them. It makes no sense at all. Do you know what kind of liability that would create? If I teach someone incorrectly and they hurt themselves or damage property, I could be sued. The HOA could be sued. This is completely irresponsible. Karen folded her hands on her desk. The board has made its decision. You can either comply or continue to accrue fines. We can also place a lien on your property if the fines go unpaid. I could not believe what I was hearing. You are threatening to put a lien on my house because I will not teach forklift classes. We are enforcing our bylaws, Mr. Zander. Nothing more, nothing less. I left before I said something I would regret. On the drive home, I called my buddy Marcus, who was a real estate attorney in Las Vegas. We played poker together twice a month, and he had helped me review documents when I bought the house. Marcus, I need some advice about my HOA. Oh boy, what did they do? I explained the situation in detail. There was a long pause on the other end. Peter, that is one of the most absurd things I have ever heard, and I have been practicing for 15 years. They cannot force you to provide professional training services. That is not what HOA bylaws are designed to do. Can they really fine me? They can try, but it would not hold up if challenged. However, here is the thing. I do not practice HOA law specifically. You need someone who specializes in it. Let me give you a name. Daniel Robertson. He is tough, knows this area inside and out, and he loves taking on overreaching HOAs. Is he expensive? Probably, but a consultation should not be too bad. And honestly, this might not take much to resolve once they get a letter from an actual lawyer. Marcus gave me the number, and I called Daniel Robertson's office the next morning. His secretary scheduled me for the following Tuesday. Daniel Robertson's office was in a modern building in downtown Henderson. The man himself was in his mid-40s, fit, with graying hair and sharp eyes that suggested he did not miss much. His office walls were covered with framed certificates and what looked like newspaper clippings about cases he had won. Mr. Zander, good to meet you. Marcus spoke highly of you. We shook hands and he gestured to a chair. Tell me about your HOA problem. I went through everything again, showing him the original letter and the fine notice. Daniel listened carefully, taking notes on a legal pad. When I finished, he leaned back in his chair. Okay, this is actually worse than I initially thought when you called. Worse how? What they are asking you to do, demanding you hand over your training materials and provide certification training, that is potentially fraud. I blinked. Fraud? Yes. Forklift certification is regulated by OSHA. You cannot just teach a class and declare someone certified. There are specific requirements, accredited training programs, documentation standards. If you were to provide training and somehow certify people, and then they went out and claimed to be certified operators based on your training, that would be fraudulent representation. I had not even thought about that angle. It gets worse for the HOA. If they are attempting to force you to commit fraud through their bylaws, they are exposing themselves to serious legal liability. Not to mention, they are definitely violating Nevada property law by trying to compel you to provide professional services as a condition of residence. So what do we do? Daniel smiled, and it was not a friendly smile. We educate them. I am going to draft a letter explaining exactly why their demand is illegal, potentially fraudulent, and opens them up to liability. I am also going to demand they rescind the fine and issue a written apology. If they refuse, We will take further action. What kind of further action? We sue them for harassment, demand they cover your legal fees, and possibly seek damages. HOAs have a lot of power, but they are not above the law. When they step over the line this badly, courts tend to slap them down hard. I felt relief wash over me for the first time in weeks. How much is this going to cost me? The letter, $500, same as their bogus fine. If we have to sue, we will talk about a retainer, but honestly, I doubt it will come to that. Most HOAs back down fast when they realize they have screwed up. We shook hands again, and I left feeling confident. Daniel said he would have the letter drafted and sent within 2 business days. The letter arrived at the HOA office that Thursday. I know because Karen called me that evening and she was furious. Mr. Zander, this is completely unnecessary. You did not need to involve a lawyer. You fined me $500 and threatened to put a lien on my house, Karen. I absolutely needed to involve a lawyer. We are simply trying to foster community cooperation. By demanding I commit fraud, did you even read the letter? Do you understand that what you are asking me to do could result in federal violations? That is ridiculous legal posturing. Your lawyer is just trying to scare us. Then call your HOA lawyer and ask them. I will wait. There was silence. We will discuss this at the next board meeting. You do that, and I want that fine rescinded. She hung up without responding. The board meeting was scheduled for the following Tuesday evening. These meetings were technically open to all residents, so I decided to attend. Jennifer came with me for moral support. The community center meeting room was set up with a long table at the front for the board members and rows of chairs for residents. About 20 people were there, which was a good turnout for a regular meeting. Most were probably there for the usual complaints about barking dogs and unkempt lawns. Karen sat in the center of the board table, flanked by 4 other board members. Dale, a retired accountant. Susan, who ran a home-based catering business. Mike, who worked in IT, and Patricia, a stay-at-home mom with 3 kids. They all looked uncomfortable except for Karen, who maintained her usual stern expression. The meeting started with routine business. Approval of last month's minutes, financial report, discussion about repainting the community center. Then came new business. Item 4, Karen announced. Resolution of complaint filed by resident Peter Zander. I straightened in my chair. Mr. Zander received a directive to participate in our community skills program and subsequently involved legal counsel rather than discussing the matter with the board. That is not accurate, I said loudly enough for everyone to hear. Karen looked at me with irritation. Excuse me, I stood up. I came to this office and spoke with you directly. You told me to either comply or keep getting fined. That is when I got a lawyer. Murmurs rippled through the other residents. Dale cleared his throat. Karen, maybe we should let Mr. Zander explain his position. Karen pursed her lips but nodded curtly. Fine. Mr. Zander, you have the floor. I walked to the front and turned to face everyone. 2 weeks ago, the HOA sent me a letter demanding I provide free forklift training to any resident who wanted it and turn over all my training materials. When I did not comply, they fined me $500. After speaking with Karen and getting nowhere, I consulted with an attorney who specializes in HOA law. I held up a copy of Daniel's letter. According to my attorney, what the HOA is demanding is not only illegal but potentially fraudulent. Forklift certification is regulated by federal OSHA standards. You cannot just teach someone to operate a forklift and call them certified. It requires accredited training programs, specific documentation, written and practical exams administered by qualified instructors. By demanding I provide this training, the HOA is essentially asking me to commit fraud. The room erupted in conversation. Dale looked shocked. Susan was shaking her head. Mike had pulled out his phone and appeared to be searching for information. Karen banged her gavel. That is an exaggeration. We simply wanted residents to have access to useful skills. But did you consult with the HOA's attorney before issuing this directive? I asked. Silence from the board table. You did not, did you? Because any lawyer would have told you this was a terrible idea. Patricia spoke up for the first time, her voice hesitant. I actually raised concerns about liability when Karen proposed this, but she said it would be fine. Karen shot her a look that could melt steel. We were acting in the community's best interest. No, I said firmly. You were overstepping your authority. The Community Improvement Clause in the bylaws is about voluntary participation in neighborhood events, not compelling residents to provide professional services. You cannot force me to teach classes. You cannot force me to hand over training materials that belong to my employer, and you definitely cannot fine me for refusing. Mike looked up from his phone. He is right. I am looking at Nevada HOA law right now. This falls way outside the scope of what an HOA can mandate. Dale was looking increasingly uncomfortable. Did we even vote on this as a board? Karen shifted in her seat. I issued the directive under my authority as president. That is not how this works, Dale said, his voice rising. Major policy decisions require a board vote. You cannot just unilaterally decide to create new requirements for residents. The meeting devolved into chaos. Residents started shouting questions at the board. Other board members were clearly upset with Karen. I caught Jennifer's eye, and she gave me a small smile. Finally, Dale stood up and banged the gavel himself. Enough. We need to sort this out properly. I move that we immediately rescind the fine against Mr. Zander and withdraw the directive regarding forklift training. Second, Susan said quickly. All in favor, Dale called. I came from Dale, Susan, Mike, and Patricia. Karen sat stone-faced, her lips pressed into a thin line. Motion carries. Mr. Zander, please accept the board's apology for this mess. Your fine is rescinded. I nodded. I appreciate that. However, there is still the matter of the time and money I spent on legal counsel because of this situation. Dale winced. How much are we talking about? $500 for the letter my attorney sent. I think it is fair that the HOA reimburse me for legal fees that resulted from an improper directive. Karen finally spoke. Absolutely not. We are not paying for your lawyer. Actually, Mike said, checking his phone again, Nevada law allows residents to recover reasonable attorney fees when challenging improper HOA actions. If he sues us, we will probably end up paying a lot more than $500. Dale sighed heavily. I move that we reimburse Mr. Zander for his legal consultation fee of $500. Second, Patricia said. This vote went the same way. 4 in favor, Karen abstaining with visible anger. Thank you, I said. I also want it noted in the meeting minutes that the HOA acknowledges this directive was improper and will not attempt anything similar in the future. So noted, Dale agreed, writing furiously on his notepad. I returned to my seat, and Jennifer squeezed my hand. The rest of the meeting was tense, with Karen barely speaking and the other board members handling most of the business. As we left, several neighbors came up to congratulate me. Todd, who had borrowed my forklift originally, apologized profusely. Man, I had no idea asking for help would lead to all this. Not your fault, I assured him. Karen was looking for any excuse to flex her authority. But the story did not end there. It turned out Karen was not done making things difficult. Over the next 2 weeks, I received 3 separate violation notices for increasingly petty things. My trash cans were visible from the street for more than 12 hours after pickup. My lawn had dandelions. My mailbox needed repainting due to minor weathering. Each notice came with a fine. $50 for the trash cans, $100 for the lawn, $75 for the mailbox. Jennifer and I both knew what was happening. She is retaliating, Jennifer said, looking at the latest notice. This is harassment. I called Daniel Robertson again. More HOA problems, he answered. Karen is hitting me with every petty violation she can find. 3 fines in 2 weeks, all for minor things that have been this way for months or years. That is retaliation, and it is illegal. Nevada law specifically prohibits HOAs from retaliating against residents who challenge their actions. Document everything. Take photos showing that other residents have the same violations but are not being cited. Then we are going to hit them with a formal complaint. I spent the weekend documenting the neighborhood. Sure enough, at least half the houses had visible trash cans beyond the 12-hour limit. Dandelions were everywhere, including in the common areas the HOA maintained. Dozens of mailboxes showed similar or worse weathering than mine. Daniel drafted another letter, this one much more aggressive. It laid out the retaliation claim with photographic evidence, cited the specific Nevada statutes Karen was violating, and demanded that all fines be rescinded immediately. It also put the board on notice that continued harassment would result in a lawsuit seeking damages and attorney fees. The letter went out on Wednesday. By Friday afternoon, my phone rang. It was Dale. Mr. Zander, this is Dale Morrison from the HOA board. I want to apologize on behalf of the board. We had an emergency meeting last night and reviewed your situation. All the recent fines have been rescinded. We have also implemented a new policy requiring board approval for any violation notices issued to residents who have been involved in disputes with the board. I appreciate that, Dale. But this pattern of behavior from Karen is concerning. What is being done about that? There was a long pause. We are handling it internally. I cannot go into details, but I can assure you that steps are being taken to ensure this does not happen again. Fair enough. Thank you for calling. After hanging up, I felt cautiously optimistic. Maybe this was finally over. It was not over. A month later, I received a letter from a lawyer I did not know. The letterhead said Patricia Donovan, attorney at law. My stomach sank as I opened it. The letter informed me that Karen Keller was suing me personally for defamation and emotional distress. She claimed that my accusations at the board meeting had damaged her reputation in the community and caused her severe mental anguish. She was seeking $50,000 in damages. I immediately called Daniel Robertson. She is what? Daniel sounded almost amused, suing me for defamation. $50,000. Forward me that letter right now. This is a slap suit. A what? Strategic lawsuit against public participation. It is a lawsuit designed to intimidate you into silence and punish you for speaking out. Nevada has strong anti-slap laws. We are going to get this dismissed, and we are probably going to get you attorney fees in the process. How is it possible that she can just sue me for telling the truth at a public meeting? She can file the suit, but that does not mean it has merit. Everything you said at that meeting was either factually true or protected opinion stated in a public forum. She has to prove your statements were false and made with malice. She cannot. This is insane. Welcome to dealing with vindictive HOA board members. I have seen this before. They get embarrassed, they lose power, and they lash out. But she picked the wrong person to mess with, and she definitely picked the wrong lawyer to go up against. Daniel filed a special motion to dismiss under Nevada's anti-slap statute within 2 weeks. The motion argued that my statements were made in a public forum regarding a matter of public concern and were protected speech. It included declarations from other board members confirming the facts I had stated at the meeting. The hearing was scheduled for August in Henderson District Court. I had never been sued before and never been to court except for a traffic ticket when I was 19. I was nervous, but Daniel was confident. Just be honest if you are asked any questions. You did nothing wrong. This whole thing is frivolous. The courtroom was smaller than I expected from watching legal dramas on TV. Judge Raymond Martinez presided, a man in his 60s with a reputation for no-nonsense rulings. Karen was there with her attorney, Patricia Donovan, a woman in her 30s wearing a business suit and carrying an expensive leather briefcase. She kept shooting me hostile looks. Daniel and I sat at the defendant's table. The proceeding started with Judge Martinez reviewing the motion. Miss Donovan, you are opposing the motion to dismiss under the anti-SLAPP statute. Yes, Your Honor. Mr. Zander made false and defamatory statements about my client in a public meeting, causing her substantial harm. What statements specifically? He accused her of demanding he commit fraud, of illegal retaliation, and of overstepping her authority as HOA president. Judge Martinez looked at the case file. I have reviewed the declarations from other board members. They confirm that Ms. Keller issued directives without board approval, that the directives would have required Mr. Zander to provide services outside the scope of HOA authority, and that Mr. Zander was subsequently issued multiple violation notices after challenging the board, which part of his statements was false. Patricia Donovan looked flustered. Your Honor, the characterization of these actions as fraud and illegal retaliation is inflammatory and defamatory. But was it false? Mr. Robertson, your response. Daniel stood smoothly. Your Honor, truth is an absolute defense to defamation. Everything Mr. Zander stated at the board meeting was factually accurate and supported by documentary evidence. Moreover, his statements were made in a public forum regarding matters of legitimate public concern, specifically the conduct of elected HOA officials. This is precisely the type of speech the anti-SLAPP statute is designed to protect. Judge Martinez nodded slowly. I am inclined to agree. Miss Donovan, does your client have any evidence that Mr. Zander's statements were actually false? The interpretation of whether the actions constituted fraud is subjective, Your Honor. But not the underlying facts. Did Miss Keller issue the directives in question? Yes, but did those directives demand Mr. Zander provide training services and materials? Yes. However, did she subsequently issue multiple violation notices to Mr. Zander after he challenged the board? Patricia Donovan's jaw tightened. Your Honor, the pattern and timing are not as clear as the defendant suggests. Daniel cut in. Your Honor, we have photographic evidence showing identical violations throughout the neighborhood that were not cited. We have testimony from board members confirming Miss Keller acted unilaterally. The pattern is extremely clear. Judge Martinez leaned back in his chair. I have heard enough. This is exactly the kind of lawsuit the anti-SLAPP statute was designed to address. Mr. Zander engaged in protected speech regarding a matter of public concern. The plaintiff has failed to demonstrate a probability of prevailing on her defamation claim. The motion to dismiss is granted. Karen audibly gasped from her seat behind her attorney's table. Furthermore, the judge continued, pursuant to Nevada's anti-SLAPP statute, the plaintiff is ordered to pay the defendant's reasonable attorney fees and costs. Mr. Robertson, please submit your fee petition within 30 days. Thank you, Your Honor. The gavel came down and it was over. Karen looked like she might cry. Patricia Donovan was packing up her briefcase with angry, jerky movements. Outside the courtroom, Daniel shook my hand. That went about as well as it could have. I will put together the fee petition. Based on the work I have done, I estimate it will be around $8,000. She has to pay that. She filed a frivolous lawsuit to intimidate you. Yes, she pays for your legal defense. That is the whole point of anti-SLAPP laws. What happens if she does not pay? We get a judgment against her personally and we can pursue collection. Garnish wages, put liens on property, all the usual collection methods. I felt a huge weight lift off my shoulders. Thank you, Daniel, seriously. Just doing my job, and honestly, this was satisfying. I hate when people abuse the legal system to bully others. 2 weeks later, I got a call from Dale again. Mr. Zander, I wanted to let you know that Karen has resigned from the board, effective immediately. Really? Yes. The judgment against her personally, combined with the way she handled this whole situation, made her position untenable. Several residents were calling for a recall election. She decided to step down. Who is taking over as president? I am, actually. At least temporarily, until we hold elections next year. And I want to assure you that the board is implementing better oversight procedures. No more unilateral decisions, mandatory legal review for significant policy changes, and clear standards for when violation notices can be issued. That sounds like good governance, Dale. I appreciate you calling. It is the least I can do. This whole thing was an embarrassment for the community. We need to do better. Life returned to normal after that. Karen moved out of the neighborhood entirely about 6 months later, apparently unable to face her neighbors after everything that had happened. I heard she sold her house at a loss just to get out quickly. The new board under Dale's leadership was actually reasonable. They focused on real community issues like fixing drainage problems and organizing legitimate volunteer events. No one ever again suggested I should teach forklift classes. But the story took one final unexpected turn in December, almost 9 months after the initial letter. I got a call from a detective with the Henderson Police Department. Detective Sarah Reeves wanted to meet with me about the HOA situation. Am I in some kind of trouble? I asked, confused. No, Mr. Zander, you are not in trouble. But we are investigating possible fraud related to the HOA, and your situation came to our attention. I would like to ask you some questions. We met at a coffee shop near my house. Detective Reeves was in her 40s, professional and direct. She had a folder full of documents. Mr. Zander, I am investigating Karen Keller and the previous HOA board administration. We received complaints from multiple residents about financial irregularities. During our investigation, your situation came up. Financial irregularities. Yes, it appears, Miss Keller was collecting fines and, in some cases, not properly reporting them to the board or depositing them into HOA accounts. We have found discrepancies totaling over $30,000 during her 3-year tenure as president. I felt my jaw drop. She was stealing from the HOA. That is what the evidence suggests. We are also looking at whether she was issuing bogus fines specifically to pocket the money. Your case is interesting because you challenged the fines and got them rescinded. But we have found at least 20 other instances where residents paid fines for questionable violations, and there is no record of those payments in the HOA accounts. So she was targeting people, fining them for fake violations and keeping the money, possibly. That is what we are trying to determine. Can you tell me about your interactions with Miss Keller and the fine you received? I went through the whole story again. Detective Reeves took detailed notes. Did she ever ask you to pay the fines directly to her? Or did all payment instructions go through official HOA channels? The notices always said to submit payment to the HOA office, but Karen was usually the only one there. I never paid any of the fines because my lawyer got them rescinded. Smart move. We have found several cases where residents paid fines in cash directly to Miss Keller, and those payments were never recorded. What is going to happen to her? If we can prove what we think happened, she will be charged with fraud, embezzlement, and theft. These are serious felonies. She could be looking at substantial prison time. The detective asked me a few more questions, took copies of all my documentation, and thanked me for my cooperation. 3 months later, in March of the following year, Karen Keller was arrested. The news made the local Henderson paper and even got picked up by some Las Vegas media outlets. The charges were extensive: 15 counts of fraud, embezzlement, and theft. The investigation had uncovered that she had stolen over $43,000 from the HOA over 3 years. Several of the bogus fines she had issued to me and others were specifically cited in the criminal complaint as examples of her fraudulent scheme. She had apparently kept 2 sets of books, one that she showed the board and another that tracked the actual money she was collecting. The case went to trial in the fall. I was called to testify about my experience with the forklift training demand and the subsequent retaliation fines. The prosecutor used my case to establish Karen's pattern of behavior: issue bogus fines, collect money, keep it for herself. Jennifer and I sat in the courtroom gallery during the verdict. The jury found Karen guilty on 12 of the 15 counts. At sentencing 2 months later, the judge gave her 4 years in prison and ordered her to pay full restitution to the HOA. As the bailiff led her away in handcuffs, I felt a strange mixture of satisfaction and sadness. Satisfaction that justice had been served, but sadness that someone had thrown away their life over something so petty and stupid. Dale, who had remained as HOA president, completely reformed how the association operated. All financial transactions now required 2-person approval. Fines could only be issued after board review. Regular audits were conducted by an outside accounting firm. The HOA even hired a part-time administrator to handle day-to-day operations, so that no one person had too much control. My forklift sat peacefully in my garage, used occasionally for legitimate projects without any interference from anyone. Todd still borrowed it from time to time, and I never charged him because that is what neighbors do for each other. The whole experience taught me several important lessons. First, HOAs can have enormous power over your life, and that power can be abused if there are not proper checks and balances. Second, it is worth fighting back when someone is clearly in the wrong, even if it is expensive and time-consuming. Third, documentation is everything. All those photos I took, all those letters I saved, all those emails I printed out, they made the difference between my word against hers and an airtight case. Most importantly, I learned that standing up to bullies works. Karen had counted on me being intimidated, on me just paying the fines and going away quietly. When I refused, when I got a lawyer and fought back, her whole house of cards collapsed. The neighborhood is better now. We actually have community events that people want to attend. The pool is open longer hours in the summer. There is a legitimate volunteer program where people can contribute their skills if they want to, but no one is forced to do anything. I still have my forklift certification, renewed every 3 years through my employer's approved training program. And nobody, absolutely nobody, has ever again suggested that I should be teaching classes on forklift operation. Sometimes I drive past the house where Karen used to live. A nice young couple bought it and fixed it up beautifully. They have no idea about the drama that preceded them, and that is probably for the best. The neighborhood has moved on. Jennifer and I occasionally joke about the whole situation. Remember when the HOA tried to make you a forklift instructor? She will say, and we will both laugh at the absurdity of it all. But I also remember sitting in that courtroom, watching Karen being led away in handcuffs, and I think about how different things might have been if I had just paid those initial fines. How many more people would she have victimized? How much more money would she have stolen in a weird way? Her targeting me with that ridiculous forklift training demand was the beginning of the end for her whole criminal enterprise. If she had just left me alone, she might have gotten away with it for years longer. But she could not help herself. She saw an opportunity to assert power, to create a new revenue stream for her embezzlement scheme, and she overplayed her hand. Daniel Robertson and I still meet for lunch occasionally. He never charges me for these lunches, even though I know his time is valuable. I think he enjoys having been part of taking down such a ridiculous case of HOA abuse. "You know," he said at one of our lunches last month, "your case is a perfect example of why I specialized in HOA law. These organizations have so much unchecked power, and most people do not know their rights. You did everything right. You pushed back, you documented everything, and you did not let them intimidate you." "I had a good lawyer," I replied. "You did, but you also had courage. Most people would have just paid the fines and tried to stay under the radar. You fought back, and it made a real difference." The legal bills from the whole ordeal were substantial, even with the reimbursements from the HOA and Karen's failed lawsuit. But it was worth every penny. Some principles are worth fighting for, and the right to not be bullied in your own neighborhood is definitely one of them. I never did share my forklift training materials with anyone in the neighborhood, and I never will. Not because I am selfish, but because that was never what it was about. It was about power and control, about one person trying to force another person to do something unreasonable just because they could. The Sunset Ridge HOA is now one of the better-run associations in Henderson, thanks to the reforms that came out of this whole mess. Property values in the neighborhood have actually increased, partly because word got around that we had cleaned house and implemented real accountability. I still work at the same logistics company, still maintain my forklift certification through proper channels, and still use my personal forklift for projects around my property. The difference is that now I can do so without worrying about some power-hungry HOA president trying to appropriate my professional credentials for their own purposes. The garage door is still the right shade of tan, approved by the HOA years ago. The mailbox is at the correct height, properly maintained. The lawn is kept neat, with only the occasional dandelion that I pull when I see it, not because I am afraid of fines, but because I take pride in my home. And that is really what home ownership should be about. Taking pride in your property, being a good neighbor, contributing to your community when you can and want to. Not being forced to do things that make no sense, not being harassed for standing up for your rights, and definitely not being victimized by people who abuse positions of trust. The forklift sits in my garage right now, clean and well maintained. It is just a tool, a piece of equipment that helps me with occasional heavy lifting projects. It was never meant to be the center of a legal battle, a criminal investigation, and a complete reformation of HOA governance in my neighborhood. But life is funny that way. Sometimes the most mundane things become pivotal for reasons no one could predict. A forklift certification, a busybody HOA president, a ridiculous demand, and a refusal to back down. That is all it took to uncover fraud, send someone to prison, and improve life for hundreds of families in the Sunset Ridge community. Looking back, I would not change a thing. Well, Maybe I would have skipped the stress and the legal bills, but I would not change standing up for myself. I would not change fighting back against unreasonable demands. And I definitely would not change the outcome. Karen Keller is in prison, serving her sentence for fraud and embezzlement. The HOA is well run and accountable. The neighborhood is thriving, and I can operate my forklift in peace without anyone demanding I turn my professional certification into some kind of mandatory community service program. Justice was served, lessons were learned, and life goes on in suburban Henderson, Nevada. The sunset still looks beautiful over the ridge that gives our community its name. The houses are well maintained, the streets are clean, and the HOA does what HOAs are supposed to do: maintain common areas and enforce reasonable rules that actually serve the community. And my forklift certification remains safely filed away with my other professional documents, shared with no one except my employer and the relevant regulatory authorities, exactly as it should be. No fraud, no illegal training programs, no absurd demands from overreaching HOA presidents. Just a man, his home, his forklift, and the peace of mind that comes from knowing he did the right thing, even when it was hard. That is worth more than any amount of money or any amount of trouble avoided by backing down. The story could have ended differently. I could have paid the fines, tried to comply with impossible demands, or just moved to a different neighborhood. But I am glad I stayed and fought, not just for myself, but for everyone else who might have been victimized by Karen's schemes if she had been allowed to continue unchecked. Sometimes standing up to bullies is not just about you. It is about everyone who comes after you. It is about making sure the same thing does not happen to someone else. It is about accountability, justice, and doing what is right even when it is inconvenient or expensive. That is the real lesson from the great Sunset Ridge HOA forklift training debacle of last year. Not that HOAs are inherently bad, but that unchecked power inevitably leads to abuse. Not that all HOA board members are criminals, but that proper oversight and accountability are essential. Not that you should fight every battle, but that some battles are absolutely worth fighting. And definitely, absolutely, unquestionably, HOAs cannot legally force you to share your professional certifications, provide training services, or do anything else that falls outside their properly defined scope of authority. They are not your employer, they are not a government agency, and they definitely are not entitled to dictate how you use your professional skills. The forklift is still mine. The certification is still mine. The training materials belong to my employer, and the HOA has no claim to any of it. That is how it was, that is how it is, and that is how it will remain, backed by Nevada law, federal regulations, and one very decisive court ruling. Life is good in Henderson. The weather is nice, the neighbors are friendly, and nobody is trying to make me teach forklift classes. What more could a guy ask for?